Hi, first podcast recording in 2025. I know we released one 2 weeks ago, but we cheated. That was recorded last year. We're back this year with a vengeance, and we kick it off with an interview with Elizabeth Wild. She's a partner at Norton Rose Fulbright, and many listeners will know her from her numerous appearances at various Alga talks and events. She was also on the board of the EPA for several years, so she's truly a fully established cornerstone in our industry. James and I chat with her about this weird thing called the duty to report. And when I say weird, I mean it's kind of unique to our industry that there is a law where people have to sort of dope themselves in. And if you don't quite know what I mean, don't worry about it. We will make it all clear during the interview. But then again, a law like that makes almost sense, and it sounds familiar in an industry where you must comply with laws that are impossible to comply with. And yes, I will never stop pointing the absurdity of the definition and the interpretation of asbestos waste out until this changes. I will not hold my breath for that to happen. And yes, that pun is 100% intended. Here's the interview. We dive in a few minutes before Liz joined us. I hope you enjoy it. It took a while until I find all my microphones and stuff again. It's a new year. Happy New Year or whatever.
Happy New Year. Yeah, it's the 24th of January when we're recording this. So it's still appropriate, I think, just to say Happy New Year. Just.
So there's no curb your enthusiasm cutoff point for you, is there?
No. There isn't.
Okay, well, Happy New Year. What did you get up to? What'd you do?
Can you just give me 1 second? I was just going to send these notes to Liz. Sorry.
2 minutes before we start, so she can prepare.
I probably shouldn't bother. I won't even bother. I already warned Liz. I was like, we fly by the seat of our pants here at BTS.
So other than catching up with sleep, what did you do?
Yeah, I put my phone in a drawer and I put my laptop in there as well, and I did not touch them for 2 weeks. And that might not sound like much of an achievement, but for me to switch off like that was actually a big deal, and it was actually really, really nice. And I got to just be present and enjoy time with my friends and my family and just not split my mind thinking about work. It was beautiful.
Elizabeth is already waiting for us, so much for our banter.
Well, we can banter when she's in here, I suppose.
I guess we can. Let me let her in here.
Hello, Liz.
Hi. I only got back from overseas 2 days ago, so I am a little jet lagged, and I was about to put my head down on my desk and have a little nap, but I thought I'll do this.
We'll try and perk you up.
I like the fly by the seat of your pants approach. That's better.
Well, and full disclosure for everyone who's listening, I actually told Liz that I would send you at least some notes an hour or so before, and I didn't even do that. So like we really are flying by this, and this is our MO at BTS. It's the only way we get these pods done is that we don't bog down too much in preparation. We have some guiding thoughts.
You've given me enough. I've done podcasts on less information than what you've given me. You said duty to report. That gives me a vague idea about what you're going to talk about.
So way more important than any of this, where have you been overseas? Where did you go?
I've been in Swedish Lapland, staying in the ice hotel.
Oh, wow.
Oh, I've been wanting to do that. Is there still enough ice?
There is plenty of ice. There's plenty of snow. Would I do it again? Absolutely no way. But I would. Was it a good experience? Yeah, look, it was amazing. I went with my son, my 20-year-old son. It was his idea. You can only do one night in the ice hotel, which I now understand why, because it is, as you would imagine, a night in the ice hotel would be. But I think if I was to recommend it to somebody, I'd say you can go and you can see the rooms, you can see the sculptures during the day, and then go and sleep in a nice warm hotel room.
Yeah.
We had a night in the ice hotel and a night in the normal luxe chalet rooms, and I would in future go and have a drink in the ice bar and go and see the rooms, and then I'd stay in the chalet. But luckily, the second night we did a 5-hour Northern Lights snowmobile tour, and there were some people on that who were actually spending the night in the ice hotel following that, which was big mistake. At least I knew after that we were going back to a warm room. To do that and then go and stay in the ice room would be not my idea of fun. But
And that's so nice you went with your son. My wife and I, we've got 3 young boys, and she sometimes worries a bit, when they grow up, they won't want to hang out with her. And I always say to her, I'm like, it doesn't have to be like...
You pay for an overseas trip, they're coming. Trust me on that one.
They'll be there. Yeah.
I was going to say, as long as you're paying, you will find they will pay and they will come. Is
good note. Okay, good note.
View on that. Yeah. So noted.
Hey, you are so a lawyer, and you know why? So last night I sent out the invite for this Zoom link here, and I'm sitting in front of the TV watching the semifinals of the tennis in the Australian Open.
Yes.
And come 2 minutes to 10 p.m., I get a notification that you have accepted my invite. I'm like, yeah, there's a lawyer working right there. And then 3 minutes later, James's recognition comes in saying, yeah, he's going to join as well. It's like, so you two.
Well, I'm just on jet lag hours at the moment, so I'm sending emails at 3 a.m. because I can't sleep.
Do you have any good lawyer jokes for us, Elizabeth?
No, I don't find them at all amusing. Sorry about that.
Neither does my wife, Liz. She's a solicitor as well. And Gunnar asked me before this pod, and I said, I'm not allowed to have them in the house. They're not allowed.
No, nothing funny about that. No, I've been the butt of them, but I can't remember it. I think I've deliberately blocked them out.
Pretty much everyone who'd be listening to this, I think, would know who you are. But in case anyone doesn't, you're a partner at Norton Rose Fulbright. You're previously at Henry Davis York in a partner position. And I think it's fair to say that you're Alga royalty.
That means old.
No, that just means that you're very involved in Alga, and anyone who's spent any time in Alga or going to Alga events, I'm sure would have come across one of your seminars or met you in an event. And I just wanted to note that you also won the 2018 Alga Lawyer of the Year, which is really impressive. It's a national organisation. So look, I think most people would have met you or be aware of your work. I mean,
I was on the board of the EPA for 5 years. If you want to say that.
Yes,
I'm not on it anymore. You can say that.
That's a really good point. And I'm sure maybe another time I'd be interested to hear about your experiences, maybe off air. So Liz is a partner in a law firm, a specialist lawyer, mainly dealing with contaminated land and POEO and pollution related matters. I think it's fair to say.
Yeah, waste. We
met each other a number of years ago just through a mutual client, and haven't really done too much together since. But I've always admired your work, and I've kept an eye on things over LinkedIn. And I thought as soon as we started doing this pod, I thought we have to get Liz on, to talk. And we thought this might be a good topic. So Gunnar, maybe Gunnar and I will come back to the housekeeping stuff at another time. How about that, Gunnar?
Sure. My house is kept. I don't know what but I actually did prepare yesterday for this. I listened to Sarah Mansfield because she gave an Alga talk. Highly recommended if anybody can get a hold of it. Same subject, duty to report.
She did that with me, I think. Yeah.
So I listened to that yesterday. So I have taken notes and have some questions.
Oh, so you got some questions from that. Yeah, well, yeah.
This episode we thought would be about duty to report. And I mean, in New South Wales, there's 2 main areas we thought we'd cover: the duty to report contamination under the CLM Act, and then the duty to report pollution incidents or pollution under the POEO Act. So roughly speaking, we thought we would do that. And I mean, we might start with the duty to report contamination. And we thought we could just have a bit of a chat about like our understanding of that. And then maybe, Liz, we had a few questions we were hoping we'd just get your take on, and maybe some of your experience in these kind of matters. I don't know, Gunnar, you know this better than I do. Do you want to just kind of start with your understanding of...
I want to start off, let's go totally basic, because so for our listeners, in our contaminated sites industry, there is something weird. Like there is a duty to report a pollution incident, so a duty of self-reporting. So if something has happened on your land and you're aware of it, and we get into the details later, but you have to actually tell on yourself to the New South Wales EPA.
Yes.
Liz, can you think of any other area of the law where you have to self-incriminate?
No, it's a good point, actually. it is criminal law, and I think people forget that environmental law is considered to be criminal law, and yet you're right. I can't think of another area like that, but I also can't think of another area where you're kind of guilty until proven innocent. So that's for the sort of director liability, issues. You're deemed to have committed the same crime as the corporation. In no other criminal kind of law is the burden of proof turned on its head like that. So it's a kind of an anomaly. The self-reporting and the burden of proof, they're unusual, and I don't think reflected in other jurisdictions either. I could be wrong there, but I'm not aware of those obligations existing. We are kind of unusual in that way, I think.
That principle of self-reporting or, kind of self-assessing whether something has gone wrong, it seems to be a principle that extends like quite broadly across a whole range of environmental legislation, like that whole self-assessment idea. And like people like Gunnar and I we just deal with this day to day, we kind of take it for granted almost, but I don't think we realize like just how unusual it is compared to other areas.
The whole general environmental duty is really interesting as well. We don't have it in New South Wales, but I think it's coming.
Yeah.
You don't have a general duty under other types of law. And that's kind of a catch-all. So if we can't get you on a specific breach, we can get you for that general environmental duty. And I think that's unusual.
Right. So what does it mean? So you are a landowner and you have engaged some environmental consultant to do an assessment. And there are findings in that assessment. And what has to happen in this assessment that would trigger the duty to report? Mind you, the consultant doesn't have to report their client. It's the client, so it's the landowner, whoever commissioned, who has to report to whom, when, and why.
Yeah. And again, when the duty first came out, there were lots of questions from consultants and lawyers also thought maybe is this going to extend to us?
Yeah, I remember that.
Having to dob our clients in, which is not what, that's a kind of scary, not great for repeat business if you're dobbing your client in, but no, I mean, it's clear that the consultant and the lawyers don't have that view. But I would say the consultant certainly has an obligation to tell the client that they have an obligation. And if the client decides not to do anything about it, I mean, that can put the consultant in a difficult position. I think auditors are in a more difficult position because they kind of owe this overriding duty sort of to the EPA and to the public. So sort of question whether they do have not a specific statutory obligation, but as part of their obligations as auditors, whether they are under a higher level of obligation. And I would argue that they probably are.
It's the same with us, Gunnar, being certified environmental practitioners, that we've got a duty to the profession. It's like we have a duty, I guess, in a number of different areas. And I think often the challenge is like you have a situation that pushes you in one direction or the other. And it's like, well, how do I meet all of those obligations at once? It can be quite hard. And yeah, so I hope, you hope that you're never put in a situation where you think there is a clear trigger for a duty to report contamination, but your client chooses to ignore that and you're put in that awkward position. You hope that doesn't happen, but I'm sure it does.
Yeah. And look, if you're in a situation, I think, where there is a real threat to human health or the environment, and obviously the higher the risk, I'd say the more you'd want to consider whether that duty does exist.
Yeah.
From a moral perspective, if nothing else. But certainly, you raise a good point with for auditors. I think it's more clear cut, but with the certification schemes that are in place now, and I haven't read the terms of those certification schemes, but whether there's probably something in there that could be interpreted as part of your obligation and your duty as a certified practitioner. There may be something in there that could be interpreted to impose that duty. And as I said, if it's a really obvious threat, a real risk of harm to human health or the environment, you'd probably want to err on the side of caution.
I like the way you explained it, Liz, which is like there's a statutory requirement that we've just talked about, but there may be non-statutory obligations outside of that. So I think we can get a bit like tunnel vision on like, the legislation says this, but I always have to check myself. It's like, don't be so narrow focused
And
on.
the legislation is drafted out. The POEO Act is actually really quite ahead of their time. It's drafted so broadly that it has required very little amendment over the years because it's a wide net, and it's up to the sort of discretion of the EPA or the courts as to how broadly they cast that net.
Yeah.
And with a general environmental duty, when that comes in, it'll be even broader. It's not anymore just black letter, looking at black letter obligations. There are so many other catch-alls. You look at EPLs, environment protection licenses, there's the sort of a duty to sort of, behave in a competent manner and those sorts of things. And they're so broadly drafted that even if you can't find even if you don't specifically trigger Section 60, and one of the things that comes up a lot is PFAS is not one of the contaminants that actually triggers a duty to notify, but it would be a brave consultant, I use that word loosely, a brave consultant or site auditor who would say, well, you've got PFAS at enormous levels and there's no duty to notify. It might not be strictly listed there, but does that mean you don't need to notify? The practice seems to be now that when it is present in significant quantities, it is being notified. So I think it will be specifically added.
We have gone way too deep into this subject already. We need to go back to the beginning here, right?
Yeah.
So an assessment has been done. Liz, what findings in that assessment, strictly speaking, would trigger a duty to report so that the landowner actually needs to notify the EPA? There are guidelines for us consultants out there. They're easy to find, relatively easy to read. I read them, of course, as part of my preparation for today. And I was quite, I wouldn't say shocked, but I was quite surprised how low the threshold for the duty to report actually is.
I mean, look, the very first, as you say, it's very easy to get caught up in the weeds of this and go down a rabbit hole. Pulling back and looking at it from a very simple view, the biggest sort of trigger is offsite. The EPA is not super excited about contamination that's confined to a site, within a site boundary, particularly when it's just soil contamination. Once you're moving beyond boundaries, you're in that territory of, regardless of what the levels are, you're in that area. And with soil contamination, when it's confined to a site, it's got to be above the trigger levels, but it's also there's got to be an exposure pathway. Whereas when you're in groundwater or surface water, because by its nature it moves off-site, you're in notification territory. But you talk about very low levels. There is still a degree of judgment I think you bring to bear with this, and you can when you look at the worked examples at the back of the guidelines that the EPA issued, there's a bunch of examples there where you might think it might technically trigger levels, but because there's no receptor or no exposure pathway. Classic example of that would be where you've got a site that's fully capped or something, and there's no exposure pathway, and there's no evidence it's moving off site. You might be above the levels, but there's that element of judgment because it's confined and it's not posing a risk. So it's still got that above the levels, and there's that sort of exposure. That second limb is exposure.
Okay.
You pay a lot more attention to groundwater and surface water because, as I said, by its nature it moves. And once you're causing potential harm to somebody else's site, or you're moving and could be going towards a sensitive receptor, that's when you sit up and take notice.
Let's talk soil contamination only. I am assessing a site, and in the guidelines, it actually says quite clearly that if I have concentrations of a contaminant that exceed my health investigation level, that is in the National Environmental Protection Measure, in the NEPM, and my upper confidence level, again, that's a statistical approach to it. So I punch all the numbers that I have for this contaminant into an equation and see if the resulting upper confidence level, which is, for all intents and purposes, a glorified or a more safe way to assess something than just an average. So it's an average plus a safety factor. So if that average plus the safety factor exceeds the Tier 1 health investigation level, strictly speaking, that site needs to be reported to the EPA. And as I'm reading that yesterday, I'm thinking, wow, that is every second site I'm on.
Well, no, I would say on a proper reading of the legislation, if it's just in the soil, there has to be a prospect of some sort of exposure.
But you have that unless, not every site or very few sites that I work on are are completely covered because you have garden areas and you have landscape areas, so someone can construe a potential pathway almost every time.
I think this is where there's an element of judgment that comes into play. So if you're talking about a site that's above those levels, and strictly speaking, and it's not capped, there is some vegetation, but it's not capped, and you're in the back of Burke or the middle of nowhere, I think there would be a good argument to say there's no need to notify. Because you've got to remember too, when you're applying those investigation levels, you are looking at the land use, you are looking at what the land is going to be put to. If you're putting a childcare centre there, obviously you're going to have, and you're above the levels, you'd be erring towards notifying. But if it's middle of nowhere, it's just going to be fallow, or going to be used for, I don't know what use it might be. It's a different approach. And the EPA makes it, when you look at the worked examples, although the legislation doesn't say this, the EPA makes it clear they're not interested in having residential sites notified to them. I mean, I understand that, because you don't want to have to do these investigations every time there's a conveyance done in, metropolitan Sydney, for example. But you could argue, on the other hand, though, that the most sensitive levels are those residential, quarter acre block type uses, and therefore is it inconsistent that those sites, the EPA specifically says in their guidelines that they don't want to know about residential sites, yet they apply the strictest levels to them. Yeah, maybe it is inconsistent, but it's certainly, it's very clear they're not interested in having residential sites notified to them.
But basically, every time a site assessment results in the recommendation of a remediation action plan, that conclusion alone, where I say, hey, this site requires remediation, that already means that the contamination levels I found are in excess of acceptable levels. So strictly speaking, every site that calls for an RAP, for a remediation action plan, is a candidate for a duty to report. Now, having said that,
but there's one other thing. The test does also have a limb that if they're above the certain levels and there's a risk of exposure, it's also, and if those levels are going to remain, if it's going to remain above those levels going forward. So you would argue, well, we've got an EMP in place, we've got an RAP in place, and that RAP requires us to do X, Y, Z. You're not going to be doing an RAP unless you are above levels, obviously. So what you say is correct. You'll be above the levels. But is it going to remain above those levels once you've addressed those issues? And if it won't, I mean, there's, again, another judgment call there. You might come up with an RAP, but you've got no certainty that anyone's going to actually implement it for the next 20 years. So you do have that risk of exposure, and you have that risk of exposure for a potentially indefinite period of time. And if you're not satisfied it's going to be implemented in the short term, maybe that would tip you towards the duty to notify. So it's not an exact science. There are different limbs, and you need to look at all of those limbs. There are a lot of different threads you need to follow through.
Would I be right in saying, Liz, that say someone came to the conclusion they weren't going to report a site, and then it was questioned at a later date by the EPA? I suppose that it sounds like the process of going through this thought process and ideally documenting that process in your report and kind of setting out your reasons. Am I right in saying that that would be seen as someone, even if someone maybe had a slightly different opinion about the pathway or the timeliness of remediation, that going through that process, I guess, is somewhat of a, I don't know if a defense is the right word, but
protective measure,
it's a mitigating factor. You attempted to go through that process,
if you just ignore it, you and as you're probably aware, the penalties for failing to report are relatively significant, but there's also a daily penalty. So let's say these factors were all present 2 years ago and you chose to ignore it. The EPA could technically, and I'm not aware of them having imposed any of them. I'm not actually aware of them convicting anybody for failure to notify. That doesn't mean they won't, but they haven't. Because there are inbuilt judgment calls that need to be made, you need to be able to document that. And often, and it's kind of it's a technical question. You guys are the ones who are going to be looking at, is it above these levels, when a lawyer's not. But many times the consultants come to us.
Yeah.
Or they advise their clients to come to us because it's not clear cut. It's above the levels, but they might say, but we're doing a cap and contain, or we're doing something, putting a slab over it, we're stabilizing it, or something like that. So there's a legal issue. Does that mean then, therefore, that we're okay and we don't need to report? And look, I would say from a client's perspective, if they've got the consultant said, look, we need this needs a little bit more looking at. You go to the lawyer says this is our view. That's going to give you a lot of protection going forward. But I know, though, if there's any grey area, my advice is generally always to notify, because there's little downside, very little downside to notifying now. It used to be, I guess a stigma on a site.
Yeah.
And also it could sit there and it could be very uncertain. There was quite a big time lag between notification, the EPA getting around to doing anything about it. You probably know there are two lists available, two registers on the EPA's website. There's the actual register once something's been decided to be requiring regulation and those sites are declared. Then you can search the list of those that have been notified, and so you always need to look at that as well. And then it'll give the EPA gives a kind of designation to tell you where it's up to in terms of assessing that site. But notifying it now, it's certainly, if there's any doubt, the safer way to go. There's the EPA's form that you fill out where you give a bit of information about why you notify it. I'd never just fill that out and send it off to the EPA. I'd always, if there's no doubt that it needs to be notified, always suggest to the client that we go to the EPA, we have a meeting and we present the consultant, the lawyer, the client, with a sort of overview of the site, where the issues are, what the reports say. And the EPA wants to see that there's a team there, that you're on top of it, that that you know what you're doing, and they put you at the bottom of the pile again. Whereas if you just send off a notification thing and you're a bit vague, you're going to get a bit of scrutiny. But if in doubt, I would always notify. It's just the safer option.
Generally speaking, in terms of timelines to come to a conclusion of that process, like, what are you seeing?
I mean, it can sit on that notification list for quite some time, and I'm saying 6 months, 12 months. You can push it, though, if you really have a drying need to know, to get it determined one way or the other. The EPA is pretty responsive to, they'll understand if you explain the circumstances that a decision needs to be made quickly. The more information you give them up front, the quicker the decision's going to be. If you just send off that form and they've got to come chasing you for more information, you could be sitting there with a wait. But if you go to them with a lot of information and you organise a meeting and you present, you can get a determination pretty quickly.
It's interesting you say that you don't see a downside to reporting. As a lawyer, I agree with you, right?
Well, yeah, it's a big call. I probably need to qualify that a little bit. If you're in that grey area, there's much more upside to reporting than there is downside. If your only thing is you're slightly above the levels and you don't have those other factors there, then no, you don't need to notify. But it needs to be backed up with, you'd actually need opinion from a consultant, and potentially even a side auditor, maybe, if you really need that extra.
And I'm totally with you. But let me give you, I can see a huge downside for reporting, and that is that the site will have a stigma because it never ever comes off that record. So as soon as you report, say you're in the middle of a property transaction, and the purchasing party finds out that your site has been reported on the contaminated land register, what commonly called, and they will immediately say, "My God, what has happened here?" And then you say, "Oh, don't worry, we have reported that, but the EPA says there's no regulation required." The other party comes back and says, "Well, that may be so, but I want to know everything about this that has happened in the past. Why has this been reported? Why does the EPA not think? Give me all your reports." And before you know it, you're in a shit fight with someone about something that may or may not be important. So when you say there isn't really a downside, I can tell you, yes, there is. There's a huge downside if you report something that doesn't need to be reported because of the stigma.
I'm probably slightly biased because 95% of the sites that make their way to me are pretty significantly contaminated. And so there's generally not a lot of grey area. But yeah, you're definitely caught up in an administrative process once you notify. But I'm talking about the downside, very little downside. If you're in that grey area, the downside of not reporting is a lot worse Let's say it turns out it should have been notified, you've sold the site, that purchaser could well have some claim against you as a vendor because you breached your obligation to notify and you were the person that caused that contamination. So it will depend on the site and the circumstances.
I was going to say, I mean, you've just touched on another area, which is like the civil damages side of things. That's because we've been talking about the EPA prosecution side or EPA regulation side of things, and there's the civil side of things as well. Which and I saw that you and your colleagues put out an interesting article the other week where there was quite a significant damages claim that was awarded. I think about 9.4 million. So that's all wrapped up in this as well. Is like there is downside to reporting, but
that's probably the biggest exposure is where you're up for the most money is, let's say, it's third-party claims. So if you've sold a site to somebody, or you don't even have to sell a site, if you've got a site and contamination from your site has migrated off to somebody else's site, they go to redevelop their site or sell it, discover it, and they come after you. And it's that third-party action for contamination that's moved off site. Now, that when you have litigation about that, it's often you're suing under negligence or nuisance, for example. And negligence is all about having a duty of care and breaching it. That duty of care will be determined by what was reasonable in the circumstances. So if you should have known that you had a duty to notify, or you should have known that there was contamination, you do nothing about it, your damages claim is going to be you'll probably be found guilty of negligence. So that's where there's a sort of mixing of the two, the statutory obligations and the civil liability claims. And if you've just blatantly ignored to the contamination, because it used to be when this duty first came in, it was a duty to notify of contamination of which you were aware. Then the language changed when the Act was amended to be contamination of which you were aware or reasonably to have been aware. It is no longer good enough to just, oh gosh, I've discovered some contamination, now I've got to investigate. If there are circumstances present that mean you should be on notice that there's potential contamination there and you ignore it, you are also going to have breached the obligation. And they look at, there's the guidelines go into this and the legislation goes into when you ought reasonably to have been aware. And that means looking at what the site's history was, what uses have been carried out on that site, what's going on in the surrounding area, what substances might have been used on the site. There's a whole.
That's what we do as part of our assessments. That's exactly what Can I give you another reason? Sorry, not another reason not to report. Another downside. Your finance is going to fall through. More likely. Because if there is if you think that some of our consultants are risk averse, you haven't spoken to any finance companies yet. So,
but they will ask the question. They will generally ask the question now, how is there contamination? So you can't just say no. You will be on notice that you'll need to at least make some very preliminary inquiries, which I would argue is something like what's the site's history? And there'd been this is a subject for a whole other podcast, but been a whole line of cases about whether there's a duty to disclose contamination or whether you can be silent. And there's cases that go both ways. But again, just keeping silent, just ignoring red flags is very dangerous.
Not what I'm advocating at all. But what I'm saying is the moment you go down the step of saying, okay, we're going to report this now, you are opening up all sorts of downsides that I need to stress here. And one of them is that your finance company is going to look at this and may jump ship and say, this is too hard basket. Because talk to a finance guy and tell them about risk and exposure pathways and God knows what. If you talk science to them, all I'm saying is, in multi-million-dollar property.
I totally agree with you, but you've got to balance that against what the potential counterworms, liability, damage claims, all of that you're exposed to if you don't make the appropriate inquiries, and if it triggers a duty to notify if you ignore that. So there's and you might not have the pain, you might avoid some admin pain if you don't notify up front, but that may well come back to bite you when you've sold the site. If there's a grey area and you can get a reasonable opinion that says you don't need to notify, that's where you want to be. But if there's red flags and issues and you are just really crossing your fingers and hoping and not notifying, that may well be a very expensive decision at some later date.
Yeah, I think what we need to be aware of as consultants, and a lot of our audience are in that space, is that, again, it comes back to like understanding what our limitations are. And like I say this all the time, like we're expected to work with legislation all the time, but we're not lawyers. And so I think what you're saying is a really good point in that, like, whereas black and white, we can probably confidently make a call. Yeah. But I think there are many scenarios that may be in a gray area, and we probably don't generally kind of cost in or budget in or manage clients' expectations to say that, look, we might have to get a legal opinion on this particular thing. And I think like one of the learnings from me from this talk so far and kind of looking into this more is like, we probably need to be like managing expectations a bit and just seeking that proper legal advice.
Yeah, because it's a very multi-layered answer. It's not straightforward. It's not just science. It's not just above the numbers. I mean, as I said, your first red flag is if you're above the levels. Yeah. But that's definitely not the answer. But when you're kind of close to or just above, there is room for interpretation, and there's good reason in many cases not to notify when you're above the levels, because you'll have those other factors like the location of the site or the lack of exposure pathways or whatever. But it is, I mean, we are very often asked by consultants they'll say in their report, this may trigger the duty to notify because it's above the health investigation levels, but we recommend you get some legal advice about whether the duty under Section 60 is triggered. Yeah. And it is a kind of a multidisciplinary sort of response that you need.
And I think, and Gunnar, I'm sure you'd agree with this. I feel that that's a bit of a handball, that kind of a comment, like, oh, you may require, you should seek. It's a bit of a handball onto the client. I think like and sometimes it's unavoidable. But certainly I think our preference, and that we've dealt with a few of these matters recently, is like, is trying to hold their hands through that a little bit. Because like you said, it's a merging of technical and legal expertise in that decision.
You can't draft these sorts of reports in a vacuum. You need to know what your client's planning to do with the site, because that's obviously going to be very relevant in terms of risk profile, because it's all about, you're not notifying just for the sake of it. It's all about notifying because there's a risk, and that risk is determined by reference to what the site's going to be used for. So there's an obligation to say to the client, okay, well, we can go out and do this and we can go and look at the levels, but you need to tell us what's your plan for the site. Because if you technically haven't triggered the levels and you say to the client there's no duty to notify, or you don't look at that issue, then you discover your client's putting in a DA to put in a childcare centre. The council or consent authority is going to ask for reports and all sorts of things, and it may then be flushed out at that point, and your client's not going to be very happy with you.
So far we have only spoken about soil contamination on site, and even that was already a bit iffy. When things become way clearer is the moment groundwater gets involved, and we have managed to contaminate groundwater, and it is my plume, my area of contamination is moving off site. I think the guidelines and the legislation is perfectly clear. The moment you have that, and that applies not only to groundwater but also to soil vapor. When vapors moving leave your site, from that moment on, it's a clear-cut case. You got to report this to the EPA. With all the ups and the downsides that we have. Now, one of the most important things is, and we have glazed over that, is, of course, when you report something to the EPA, that is not equal with the EPA requiring regulation. Yeah. That's completely different. Yeah. James, anything else you have to say? Because I have a couple of generic legal questions for Liz.
I just want to recap on something you said that was really interesting as well, Liz, which was like the kind of awareness to like a reasonableness of knowing that your site may be contaminated. I just find that interesting because I was just going to say, Gunnar, we always say that like there's often like a trigger that gets someone to go out and get an assessment done on their site. And that might be like a property transaction or a development application or something like that. But it's interesting for people who own sites that are likely to be contaminated, that like they may not necessarily be able to wait until that trigger point. They may have a obligation, or like they may have been expected to know that it should be investigated prior to that. So I just found that a very interesting point. But yeah, sorry, that's it from me. Gonna go jump into it with your groundwater examples.
We can talk another time about pollution. I mean, reporting about pollution. It's a different. Yeah,
it's a
different subject.
Quite different.
here we go. You mentioned several times now that PFAS, so these famous forever chemicals, are on the fringe of having to be notified. Tell us why.
I mean, that's going to happen. I've no doubt that's going to be added to the list, but they haven't been yet because, and I've asked this question of the regulator and have been told, well, we're waiting for the NEMP, the next version of the NEMP to come out. You know, the National Environment, they're very confusing about the NEPM and the NEMP, but the National Environmental Management Plan for PFAS, which has been delayed and delayed and delayed, but apparent, and I think it was delayed because they were trying to deal with drinking water levels of PFAS in drinking water guidelines and that sort of thing. But they're expected, as I was told, first quarter of this year, and I think that once that comes out, I think you'll then see duty to notify incorporating PFAS. But most consultants I work with now are notifying PFAS. If, as I said before, if it's just PFAS, unless it was some sort of significant level, that won't necessarily cause them to suggest that the duty's been triggered. But if it's there along with other contaminants, then they'll be including PFAS as well.
Well, the issue is a totally different one, if you ask me. So the reason why PFAS isn't because the duty to report refers to the NEPM, the National Environmental Protection Measure, and anything that exceeds the levels that are outlined in there.
Not in PFAS,
And PFAS at that stage wasn't in fashion yet.
Yeah, well, that is the reason. That is the reason why it's not triggered at the moment.
So the underlying problem is not that we have now new chemicals that we are aware of, but the underlying problem is that somebody thought it was a smart idea to entrench a scientific paper, which the NEPM basically is, to entrench a scientific publication, which is by its pure definition a moving beast, because information comes in all the time.
I agree.
And
it's
gets
static.
updated. Right? And it has been entrenched into a static law, and whichever brainchild came up with that idea needs to answer for that. That is just unbelievable nonsense.
That's why I always think you've got to draw back and say, why would this duty to notify be there in the first place? Not just so that the EPA can be burdened down with a whole bunch of notifications. It's because the site poses a risk. And so to say, well, it doesn't technically, that contaminant's not in the NEP and therefore I don't need to notify. If it poses a risk, it poses a risk. And your very profession is about advising on environmental risk from contamination, posed by contamination. So to say, well, I'm not going to notify this because it's not in the Schedule B1 or whatever it is of the NEPM, is kind of clouding the rest of your obligations, your general obligation as a consultant, which is to advise your client of risks posed by contamination.
You mentioned terms and conditions.
Well, there's a whole other
podcast. Can you give me the most useless sentence that is usually in terms and conditions by consultants, and one that is actually making sense?
I know this is going to raises a whole other thing, but the whole thing that no one can rely on this except for the client does not protect you from negligence, claims in negligence. It narrows the contractual obligations to the person that you're contracting with, but negligence is a duty that's owed beyond that. So that is and there's a whole lot of other issues. I think that has to be the next topic, because that's one that's a very, very badly understood area. And I think in attempting to try and limit their liability, I think many consultants are actually putting themselves in a worse position. They're saying no one can rely. They're better off saying, if someone does rely, tell me, and then you have the opportunity to enter into a contractual arrangement with that person. And all your things like your limits of liability, and it's limited to redoing the job, et cetera, you can impose those things. If you don't have that contractual obligation, you can be subject to unlimited liability. But that is definitely an issue for another day, because that's a very broad.
That's a very nice teaser, I think, for another episode. And I'm sure I personally would love to hear that, actually. We'll definitely have to get you back on, Liz, to talk about that if you're willing. And we'll let you go. We know you got another meeting, so we really appreciate your time going through this with us. And
it shows that I don't get out enough, that I found this the most fascinating conversation I've had quite some time. So it
I'm
shows
so
clearly
glad.
could talk for hours, but no, I'd love to think.
I'm sitting here thinking, man, how am I going to cut this together that people don't fall asleep? I'm sorry.
Well, clearly your audience is other contaminated land geeks.
Gunnar, you think our audience loves this stuff? Nobody's falling asleep. Trust me, our audience loves it.
Well, I love talking about it. So anytime you want to talk about that or any other issues, I'm very happy to.
Thanks.
And also thanks for what you're doing for our industry in general. That's
Yes.
much appreciated.
Well, I love that the lawyer that we feel part of this industry. It's not just consultants. There's a lot more of, there are other professionals that make up the industry. So we've all got an obligation to improve things. So yeah. But thank you. I've loved having a chat.
Thanks so much, Liz. Talk to you again soon.